Hello, everyone, and welcome to Crime and Court. My name is Heather. I am currently recovering from hip surgery, and it's a little hard to sit up, so I'm laying down. So, this is going to be voiceover only. You're talking about the Menendez brothers, California versus Erik and Lyle Menendez, and this is part two of the Amicus Curiae, which we're reading through. We've streamed through the entire trial, and now we're going through sort of the appeals process and some of the other filings that have taken place after their second trial ended, which was in 1996. So we streamed the 1993 trial, and that ended in a mistrial, as we know. So they went to trial a second time in 1996. They were convicted of first degree homicide of their parents, and they've been serving life without parole ever since. Erik was 18 at the time of his arrest, and Lyle was 21. So they've been in prison their entire adult lives, basically. And their entire childhood was torturous and sadistic because of their parents and what they did to them. Both parents were pretty awful. Can't really say which one's worse. Probably Jose, if you were to count one, but their mother was also pretty awful. Well, anyways, we don't need to rehash all of the details, but I am going to go back just a little bit in the document that we were reading. So this is, oh, here, let me switch screens. Sorry. So this is the Amicus Curiae, which was brought forth by the American Psychological Association and also the California Psychological Association, also known as in this document APA and the CPA. And they are giving the Superior Court, this was during the appeals process, apparently, and they were giving the appeals court information. That's what an amicus curiae is. It's like we're not really party to this particular case, but we have some information that might help the judge make a better decision. So they brought forth this information, and it's basically they're arguing that patient therapist confidentiality shouldn't be eliminated once the therapist feels like they're threatened or there's some kind of threatening situation going on because of the fact that Dr. Oziel, the therapist that Erik was seeing and went and confessed to, Dr. Oziel then recorded their conversations, and because he said he felt threatened by Lyle and that Lyle threatened his life, whatever, Lyle and Erik tell it a little differently. So, and I don't believe everything Oziel says because if you watch his testimony, you could tell he's just not credible. Um, so yeah, so because he felt intimidated by the brothers, he said, the whole argument is that that confidentiality patient thing goes out the window and all of those recordings that he did come into trial. Well, the APA and the CPA are saying, no, that's not the case, and here's why. And they're trying to argue it using this, well, they're using many cases, but in particular, they're using this Wharton case, which we've talked about previously. This is part two. Like I said, we've already read through 20 something pages of this. So like I said, I backed up just a little to get us into the context of what we're talking about. So, the Court of Appeal ruling is both unreasonable and unworkable. It is unreasonable because it would destroy confidentiality even as to the patient therapist communications that have nothing to do with the subject of the threats or warnings. It it is unworkable because it fails, unlike Wharton, to provide any pragmatic way of distinguishing what is privileged from what is not. Sorry, I like to highlight as we go along, so I'm going to switch my thing over. All right, so consider, for example, a patient who agrees to undergo therapy because of depression over job related stress. Assume further, During the course of the therapy sessions, the patient also discusses his marital problems and financial troubles. After several months, the patient communicates to his therapist a threat against the patient's supervisor. So the patient is like, hey, my boss, I'm going to do something to him, whatever it is. So he is, the supervisor or the patient is feeling that he's trying to push me too hard, he says, and that the therapist goes and he warns the supervisor after this threat happens in therapy. So finally assume that the patient later becomes involved in a divorce. Under the Court of Appeal ruling, confidentiality is destroyed not only for the patient's statement in therapy after about his supervisor, but for everything that he said in sessions prior. So this whole confidentiality goes out the window and all of the prior things come in. That's not fair and that's not how it should be. So they're saying that this is not, it's unworkable and unreasonable. The therapist presumably can testify in the divorce action about what the patient said about his wife, can testify in a creditor suit about what the patient said about his unpaid bills, and so on. So obviously, this goes on and on and on. This is a truly bad rule of law because, and they're going to go into this, people in conversation don't always stick to the same conversation. A lot of times they'll go from one conversation to another. They don't finish one thought and they move on to another conversation and they don't go in a nice timely organized chain of events. They might start at the end or the middle. They don't always start at the beginning and go to the end. So therapy sessions are, especially, in therapy sessions where a therapist might stop and disengage you from your story because they want to do, or they want to ask you some questions, or they might want to do some kind of whatever exercise. Um, so they might stop you, and then, you lose your train of thought. You don't get everything out. So you might come back and do it in your next session or 2 sessions from now, you come back and circle to that because maybe it wasn't bothering you back then, but it's bothering you again now. So, it's not, therapy isn't just, one single chain of events in a sequence of, a timeline that, is easy and neat, put up in a bundle. So that's all I was going to say about that. So they're going to talk about this in the next paragraph here. And this is about where we left off. So, in therapy sessions, patients do not usually discuss a neatly organized sequence of subjects. They jumble together a lot of concerns. The Court of Appeal ruling means that if a patient discusses not only subject A, the threat to harm someone, so that's subject A, but also subject Z, which is completely irrelevant to subject A, confidentiality is lost to subject Z as well as subject A. So this is not a speculative inference about the Court of Appeal ruling. So whatever the ruling was saying that this all could come in and that the confidentiality was broken, this is them arguing that's really ridiculous. So the Court of Appeal itself cited the Superior Court's finding that each session was related to and inextricably intertwined with the one that preceded and followed it. On this theory, virtually everything said in therapy is intertwined with the subject of later testimony. So, like I said, it's all a big web of everything. You talk about everything in your life in therapy, and one week your boss might be bothering you, the next week your wife might be bothering you, and the following week it might be your kid, it might be finances, it might be religion, who knows what it is. Um those kinds of things, it's not all, like I said, in a perfect bundle. Life's not in a perfect bundle. So the Court of Appeals ruling gives little guidance for determining what nexus, if any, between statements made in previous sessions and the threat made in a later session is necessary to justify the disclosure of the content of the prior. So they're going back to prior therapy sessions. The Court of Appeal seems to accept the ruling of the Superior Court in this case that all sessions are a seamless part of a single whole, and that in Statute 1024, therefore, authorizes the disclosure of all communications made during any session for a patient who at any time voices a threat. And that's coming from, or that's the Menendez case being quoted, apparently. All right, so many patients continue in therapy for years. This would mean that if a threat was made in 91, let's say, sessions from 1987 might no longer be privileged if they were intertwined in the seamless web of therapy. This is hardly the narrow exception intended by the legislature. Such a rule also violates the constitutional right to privacy. It contravenes the well settled rule that a statutory exception to such an established privilege is constitutional only when it is narrowly limited to disclosure of directly relevant information. Directly relevant, it must be. So, in stark contrast to the Court of Appeal's all or none approach, Wharton provides a far more judicious, reasonable rule. Under Wharton, the therapist is permitted to disclose those things and only those things, oops, that was crooked, that are needed to achieve protection of society. So they only can disclose the threat, not anything before the threat, not anything after the threat, just that threat. Everything else should be confidential. The warnings themselves and certain statements that are closely related to the threat because they helped trigger the warning. So anything, context-wise up until that threat, but not you can't go back 4 years and take everything that this person's ever said about their boss. This should be sufficient to protect potential victims and society. If a therapist warns a patient's supervisor saying John Smith can't control his anger and has threatened to shoot you, ordinarily this is sufficient to allow the supervisor or the police to take protective action. But it would not increase safety for the therapist to add disclosures such as, would you like to know what he said about his wife? Or he has poor control of his impulses because of his parents. Let's get into that. Let's talk about his childhood. That would be totally and completely improper. So you see, putting it in this context, the way that they're arguing it makes perfect sense, and you wouldn't do that because that would just be ridiculous. The Wharton rule does not depend on rigid criteria such as whether two subjects happened to be discussed in a single therapy session. The rule permits the disclosure of all trigger statements and prohibits the disclosure of all statements that do not trigger a Tarasov warning, regardless of when the statements were made. The Wharton rule is consistent with the legislature's intent because it permits the disclosure only of those statements that are in fact necessary to ensure the public safety. So again, that public safety part is the only thing that really matters. The rest of it should be confidential. Surely this is the outer bounds of what can be read into the statutory exception that permits disclosure of the communication that is necessary to prevent the threatened danger. The communication referred to in the statute is the threat itself or the statement of how it will be implemented. The statute does not refer to the content of all prior therapy sessions. Thus, the plain language of 1024 limits the dangerous patient exception to the actual content of Tarasov warnings themselves. While, as Wharton holds, public safety concerns may provide a rationale for extending the exception to include triggering statements, it is clear that the Court of Appeal ruling pushes the language of 1024 beyond its breaking point. So they're saying the Court of Appeals has stretched this statute beyond what it should be. This court should vacate the Court of Appeals decision and instruct the lower court to make appropriate factual findings pursuant to Wharton. In its answer brief, the real party in interest raises a side argument. It argues that Wharton was wrongly decided because it could not be appealed in cases where no warnings is actually given, even though in retrospect, the psychotherapist had reasonable cause to believe that the patient was dangerous. It assumes that one cannot identify statements that trigger a warning that should have been but never was given. Even assuming, arguendo, that 1024 was intended to provide an exception to the privilege where no warning actually is given, which is doubtful, the real party in interest's arguments do not discredit the Wharton analysis. We have a footnote here. Reading 1024 narrowly, as is mandated by the law, it is likely that the exception to the privileges was meant to apply only in cases where a warning actually was given. The real party in interest suggests that the phrase reasonable cause to believe was intended to mean that it is relevant whether a warning actually was given, but it is far more likely that this language was designed to ensure that 1024 covered situations where a warning was actually given but the patient ultimately proved not to be dangerous. This is the reason 1024 did not say that there is no privilege if the patient proves to be dangerous. So, regardless of whether the person is or isn't dangerous, the rule should apply. Is how I read that, unless I'm confused. But that's what they said. All right. So if the therapist, or that's how I read it. So, if the therapist is determined to have had reasonable cause to issue a warning but did not do so, the court can first determine that the therapist had reasonable cause to believe a warning was necessary, and then ascertain which statements of the patient triggered such reasonable cause. In Mavroudis versus Superior Court of San Mateo County, the court described the mechanism for for determining whether 1024 applies in cases where no warning actually is given. In such cases, a trial court should examine the evidence in camera. That means out of court or basically in their chambers, but it could be on the record. But they look at the evidence in their chambers off, no camera, nothing. I don't know why they say in camera, but it does mean like in their office or chambers. So they'll be looking at this evidence to determine if the factual predicates of 1024 are satisfied, i.e., whether the therapist had reasonable cause to believe that the patient was dangerous and that the disclosure of privileged communications was necessary to prevent the danger. The Wharton ruling extends this analysis by requiring the court to determine which statements by the patient should have triggered such a warning. So you need to provide the court with the actual statements. For example, if a patient said to a therapist that he was going to KILL his wife, and the therapist failed to warn his wife, and the testimony was later sought concerning this, the court would first decide whether the threat gave the therapist reasonable cause. So just because he said it, it might have been like he said it in jest. I thought he was joking. He didn't really say, he's always said that or whatever, like whatever the case may be, and he didn't think that there was reasonable cause that it actually rose to the level of where it needed to be a warning because he never thought he would actually act on it. Maybe it was, not in those exact terms and it was in a joking manner, but then he acted on it and now the therapist is being questioned as to why. He has to prove the reasonable cause. Well, it was a joke. He's always joked about it and I've seen them together and she's even joked about it, something like that. So, maybe that would be like whatever. Not that that's a joke, but a therapist should actually see that as a concern, but for whatever reason, that it didn't concern them. It didn't rise to that level, so no warning. Of course, trial courts should be reminded that hindsight is always 2020 and that therapists frequently will not have reasonable cause in advance to believe that the patient is dangerous or to know who they may harm. In any event, the real party in interests argument in no way discredits Wharton. Unnecessary expansion of the scope of 1024 would harm many non-dangerous patients and the public. The real party in interest in this case seeks to protect the public, yet ironically, the judicial ruling it seeks would inevitably have the opposite effect. If potentially dangerous mentally ill persons knew that if they say anything in therapy that gives their therapist reasonable cause to believe that they may harm the therapist or someone else, then confidentiality will be lost as to everything they have said or may say in the future. Many of these patients either will never enter therapy or will try to hide their real thoughts and feelings. In either event, there will be less effective therapy and more danger to society. If we just throw out this whole confidentiality, then no one's going to tell us anything. As this court has acknowledged, psychotherapists cannot predict with reliable accuracy whether patients will be dangerous. We have another footnote here, and it looks like a bunch of gobbledygook. We recognize the difficulty that a therapist encounters in attempting to forecast whether a patient presents a serious danger of violence. Describing as unequivocal the evidence that therapists are unable to predict accurately future violence or dangerousness. So basically, they're saying it's a therapist is not adequately prepared or or doesn't have psychic abilities to be able to predict which of their patients might just become violent or dangerous and which of them might actually be a danger to society and when a warning is necessary. So it's not on them. That this is basically what the courts in these other cases have said. It's not on the therapist to predict it. The scientific literature contains copious empirical evidence that given the current state of scientific development, psychologists, psychiatrists, and other therapists are not able reliably to predict future dangerous conduct. Not able reliably to predict future dangerous conduct, especially for people without a prior record of such violence. And now we have another footnote. Psychotherapy and violence, a review of the literature, development of a clinical instrument to eliminate self deletion risk. So these are all the sources. Um, yeah, these are just titles and sources. Okay. So one of the leading experts who has exhaustively surveyed the literature concludes that when it is possible to use the most sophisticated multivariate analysis, predictions of violence are accurate only 10 to 30% of the time. So even with the best kinds of um what am I what word am I looking for? Like the best organized um evaluation. Sorry, my brain just fried for a second. When trying to predict violence, we still can only do it 10 to 30% of the time. It is not a predictable thing, necessarily by what we know. So another leading expert concludes, oh wait, did I missed a thing. Okay, these are just sources now. At least 8, 7, and 8 are. All right, another leading expert concludes that nowhere in the research literature is there any documentation that clinicians can predict dangerous behavior beyond a level of chance. So it is like 50-50 flipping a coin. chance whether a person will become dangerous or not. Research also demonstrates that I don't know if it's really 50-50, but, um, chance to me is, fork in the road, which way do you go? Flip a coin, you got one choice or another. Research also demonstrates that psychotherapists tend to overpredict dangerousness. For every case in which they do not predict violence and it occurs, there are several cases where they do predict violence and it does not occur. So they're not accurate. For example, several studies have tracked patients who were institutionalized in maximum security correctional mental hospitals because they were considered dangerous, but were released because of deficiencies in the prior proceedings. One study found that only 20% of these patients, all of whom had been labeled as dangerous, committed violent acts following their release. So only 20%. um, i.e., there were 4 false positives for every true positive. A second study found that only 14% of released patients committed violent acts, i.e., 6 false positives for every true positive. And it looks like the rest is all sources for that. So that was very interesting. All right. Where did I leave off now? All right. In the parlance of the scientific literature, there are several false positives for every false negative. So again, it's chance, like we said above. So an American Psychiatrist Association task force stated that every study performed in this area has demonstrated that mental health professionals have strikingly high false positive ratios in the neighborhood of 4 to 1 to 3 to 1. Give another. Okay, that's just a source. These footnotes that are just sources drive me nuts because it disrupts the flow. All right, so thus, any rule ending confidentiality for those who are predicted to be violent and for whom warnings are given will end confidentiality for many more people who are not, in fact, dangerous. As one expert notes, suppose 0.2% of all patients are in fact dangerous, and suppose further that psychotherapists could in the future develop a test that could predict dangerousness with 95% accuracy, an overlay optimistic assumption. Under these circumstances, out of 10,000 patients, 20 would in fact be dangerous, and psychotherapists would correctly identify 19 of these patients. However, psychotherapists would falsely overpredict that 499 other patients would be dangerous. Thus, to prevent 19 episodes of major violence, the psychiatrist will attempt to protect the potential victims in over 500 cases. That's a very low rate in um, when you put it, relative to that. So 19 plus the 499 equals 518. And okay, so this bedeviling problem of prediction is not just a theoretical one. It is a practical limitation that has been acknowledged by this court. Required warnings in this case of each person who has a history of violence and who has made a generalized threat to unidentified persons at some time would, in our view, require a cacophony of warnings that, by reason of their sheer volume, would add little to the effective protection of the public. So basically, they're saying there would be so many instances where there might be possible warnings if you're going by this low threshold that, um, you know, then it wouldn't even be helping the public. It would just be giving out all these warnings for no reason. Given the inherent limitations of trying to predict violent conduct, the Court of Appeals interpretation of Evidence Code 1024 in this case would result in disastrous consequences for many people. I also want to say that this is because you can't predict future violence acts, even if they have cons- con- um, possibly done a violent act. Like this, maybe this argument could even help their resentencing because they um, it's unpredictable and you can't predict who might be violent in the future. Even though they have been violent, like there's nothing showing that um, they might be violent going forward. Where was I? All right. In the example above, the therapist would predict harm and would warn the victims in 518 cases. In 19 cases, the therapist would predict correctly, but in addition, 499 people who posed no risk would totally lose confidentiality of their therapy records. And 499 people would also be warned for no reason and somehow creating more chaos in that patient's life by, you tell your boss or the person's boss or the person's wife that there was some minor threat and that actually they pose no risk at all, but here you are creating chaos in that patient's life by having to, deal with more problems with that person, if that makes sense. So this bad result would be multiplied because under People versus Clark, any statement revealed to a third party in a non-privileged communication, such as a warning, loses its confidentiality status for any purpose. Once patient statements have been disclosed pursuant to 1024, the statements are no longer confidential, and arguably other parties could therefore spread the statements without fear of legal repercussion. So does that mean if I'm getting a divorce with my husband and he's a politician and he's got all this stuff in his, on his computer that might, cause a big scandal and I got this information, I got more information from his therapist and it's no longer confidential, I could just go ahead and release that to the public and just wreak havoc in his life. Do you see how there's like no, there has to be a line drawn? You can't just go after everything that a patient reveals in their sessions with a therapist. Thus, not only does the patient who unwittingly is a false positive lose the privilege to keep confidential information out of court proceedings, but he or she also might lose the right to have such information kept confidential in out of court contexts, such as employment or insurance. Yeah, I could go to somebody's boss and be like, look, I found, he's threatening his wife over here, but I want you to know, and here's if I'm the therapist, here's all of his information he's ever said about you, even though he's never said anything about you, but he could be potentially dangerous. You see how that is problematic, and where does it end? Do you go to his, you go to his boss, you go to his wife, you go to his other family members. Like, where does it end? Where do you stop at? Okay, he talked about this person a long time ago. Do I go talk to that person and give him confidential information that's no longer confidential because he threatened somebody? It just doesn't make the argument doesn't make any sense. So this is an intolerable result. In sum, this court should reject the Court of Appeals' novel creation of a truck-sized hole in the general rule of confidentiality because it would harm large numbers of innocent and harmless patients. And I'm going to back up because I missed this. I missed this footnote here. All right, so APA believes that Clark went too far in declaring broadly that the reason for the privilege protecting the patient's right to privacy and promoting the therapeutic relationship, and thus the privacy itself disappears once the communication is no longer confidential. For example, suppose that two therapists, Dr. Smith and Dr. Jones, both are treating patient Brown, who is having marital problems. At a party, Smith reveals intimate and embarrassing details of Brown's personal life to a visitor from out of town. The visitor is not interested and leaves town without repeating the disclosure. Under Clark, such details are no longer confidential, and although Dr. Smith may be liable for the initial disclosure, Dr. Jones may now repeat the disclosure to anyone he wishes. Yeah, that's a problem. So even though the patient is not at fault for the initial disclosure, even though the initial disclosure by Dr. Smith was unethical, and even though the initial damage to the patient was slight because the third party was an uninterested stranger, the patient forfeits forever his crucial right to confidentiality. The dictum in Clark should be disavowed because the confidentiality of a patient communication should depend on the patient's reasonable expectations, not the actions of the therapist. That's a good rule of thumb. Not it should the confidentiality should be that of the patient's expectations, not the therapist's. I highlighted the wrong thing there. Sorry. And my mind was somewhere else. All right. So communications are confidential if transmitted by a patient in such a manner that so far as the patient is aware, discloses the communication only to the therapist. Hang on one second. Sorry. Okay. Um. Next section, the Court of Appeal erred in holding that the patient-therapist relationship terminated as soon as Dr. Ozio felt threatened. The Court of Appeal ruled that the November 28th and the December 11th sessions that occurred subsequent to Dr. Ozio's Tarasov warnings were not privileged because the therapist-patient relationship instantaneously ceased to exist at the moment of petitioner's threats against Dr. Oziel. But I also want to say, so does it even work if Lyle wasn't even his patient and Lyle's the one that supposedly threatened Oziel, not Erik? So how are Erik's sessions then available to the court and available to come into the um, proceedings? I don't get that. That would be an interesting argument too if you argued, well, it's Lyle who did the threatening, supposedly the alleged threatening, and Erik is the patient, not Lyle. I would argue that, but whatever. All right, so where was I? Menendez, blah blah blah. This ruling is not grounded in law, is contrary This ruling is not grounded in law, is contrary to the established facts of clinical practice, and could have potentially disastrous consequences for both therapy patients and the general public. Patients' threats against therapists are relatively common and do not always foreclose successful therapy. Research on clinical practice has shown that many therapy patients express threats of violence against their therapists. Really? So many patients express threats against their therapists. That's interesting. The psychotherapeutic relationship often results in negative transference directed by patients toward the therapist, i.e., many patients begin to view the therapist in the form of other authority figures in the patient's life and begin to have strong and sometimes negative feelings toward the therapist, reflecting the patient's true feelings towards these other individuals. And before I read that footnote, another instance of where a patient might get mad at their therapist is if their therapist is, you know, pushing them to act on certain things in their life, like keeping a diary, and maybe they resent doing that because it's bringing up feelings that they didn't want to feel, or maybe the therapist is pushing them to make amends with a family member or a friend or something, and you're resistant to as the patient, so you kind of that resistance you transfer onto your therapist because that you see them as the one that's making you do it, so to speak, even though it's something that it would benefit you and be beneficial if you did the work and went through the process that your therapist is offering you or suggesting to you, and it would benefit your relationships or benefit your job or whatever it might be. So they can see the therapist as, an obstruction of, well, I like living in my little bubble of denial and you're making me do things that I don't want to do. So 12, at this footnote, describing transference as the emotional response that the patient in therapy has toward the therapist, in which the patient unconsciously attributes to the therapist those feelings that may have been supposed towards others close to that patient, such as a parent. So if you maybe go to therapy regularly and you talk about your parents, you might start to think of your therapist as your parent or like a parental figure because you're working on that and somehow that fills your void and whatever. So, transference is the projection of feelings, thoughts, and wishes onto the therapist who has come to represent an object from the patient's past. The therapist is reacted the therapist is reacted to as though he were someone from the patient's past. Transference may be positive or it may be negative, as when the patient dislikes or hates the therapist. Maybe you have hatred towards your father and you transfer that onto your therapist. Management of aggression. Oh, that's sorry. That is the source. I'm going to read that, right? Describing treatment. Okay, so there is something to read here. Sorry. Describing treatment of patients suffering from narcissistic disorders, the author notes that it is clear that the therapist's treatment plan must sooner or later release the powerful hatred of such patients towards the analyst. So, letting go of that hatred towards the object of your hate, whether that's the therapist or your um, parents, you need to let that go, working on letting that go. All right, we're going to scroll all the way up to here. Obviously, therapists do not encourage patients to threaten or commit acts of violence. However, in certain cases, such acting out against the therapist is an emanation of the negative feelings experienced by the patient. So they're letting out, they're kind of releasing that by transferring it onto the therapist, the way for them to express those feelings. Moreover, such threats do not always signal the end of a successful treatment. On the contrary, for some patients, this is an unavoidable part of the therapeutic process. The expression of previously suppressed anger can signal a breakthrough in therapy and can be an important stepping stone to achieving therapeutic goals. As one therapist has noted, if too little negative transference is mobilized, the patient is deprived of the opportunity to relive crucial relationships and experiences. It is not surprising, then, that threats by patients against therapists are fairly common, although carrying out such threats may be rare. So, even though you may threaten your therapist because you think of them as your deceased grandfather who you hated for whatever reason, um, you don't act on it because in reality, you know that your therapist isn't the one that you're really mad about mad at, and you don't act out on it because in reality, that would be wrong. So a lot of times, you transfer that anger and it's misplaced, obviously, but it's part of the process, part of the therapeutic process. Um, or it can be part of the therapeutic process. Not everybody does this, but some people can. So, in one recent study of 150 psychiatrists in Oregon, 61% of the respondents had experienced direct verbal threats of physical harm at some point in their career. 30% had received written threats, and 35% had received phone threats. However, only 7% had actually experienced the threatened result. Nevertheless, the author concludes that threats and assaults are relatively frequent occurrences in the careers of responding psychiatrists. I mean, it just goes with the territory because you're dealing with people's emotions and things can trigger that. And you're trying to heal things and you're stirring up and remembering things that you maybe not you don't want to think about, and that causes emotional and sometimes violent reactions. Another survey of 300 psychotherapists revealed that 81% experienced at least one episode of physical attack, verbal abuse, or other harassment from patients. That's horrible. 81%? Ty, Tryon. Oh, sorry. That is another source. I keep reading the sources. They're confusing me. A review of the literature in the same article revealed that approximately 40% of all therapists feel physically threatened by their patients at one point or another. Did I read 40% feel threatened? So even though 81% have received some kind of physical, verbal, or other kind of harassment from their patient, only 40% actually feel threatened. So that goes to show 41% may get these attacks, but they don't actually feel threatened by their patient because they don't believe that their patient is actually a dangerous person for whatever reason. All right, so there's a survey here finding that 49% of all therapists had been threatened with physical attack by their patients, and 40% had actually been attacked. So there's a 9% that didn't get attacked, they're saying here. Out of that, more than 40% of psychiatrists had been assaulted by a patient. 21% of patients pose a threat to the therapist, and 1 in 160 actually assault the therapist. 1 in 160. In fact, while no one knows how often psychologists are physically attacked by their patients, extensive underreporting makes it likely to be more frequent than it is currently believed. It is surprising, perhaps, but true, that such threats can be absorbed and deflected by dedicated therapists who can continue to help the patient. In one study of actual attacks. So in the first meeting, apparently, or allegedly, Lyle threatens Oziel. This was when Erik was in therapy. He was in his therapy session with Oziel, and this is the first time he admits to Oziel that he shot his parents, him and Lyle. At this point, they were out for a walk. At this point, Dr. Oziel brought Erik back into the office. They called Lyle and told Lyle to come in immediately because this was an emergency and he confessed and he needed to talk to them both in his office. So Lyle came in immediately. They spoke for a little bit and then left. Lyle was very unreceptive, and according to Oziel, he, as on his way out, there was no recording of this. On his way out, he apparently threatened Oziel's life, meaning he had to they had to take care of him too. In some, they said it in a way like that, not directly saying we're going to KILL you, but something, something insinuating it. You could infer it by what they said. But it was Lyle, again, not Erik, who made the threat. So again, should Erik's therapy sessions come in if Lyle's not even the patient? I don't think so, but maybe it's not confidential if, another person's sitting in on the session. Who knows? Maybe that was something that they argued too, the state. So, another survey noted that usually the therapists continued to see the patients after experiencing physical assaults, and that a number of practitioners indicated subsequent positive treatment outcomes. So, whoops, crooked as heck. Um, so, even though a therapist might have been threatened by a patient, they might have even been physically attacked by a patient. If they continue therapy sessions, they can get a positive outcome. So, like I said, the first session was the supposed threat, but Lyle was coming back multiple times to, or at least a second time, to go through it again with Dr. Oziel, and I don't believe that they really got anywhere with that, but that was the tape that one of the tapes that they played in the trial, and where Dr. Oziel does most of the talking and tries to fill in the gaps and says, "Well, your father was controlling, so that's why you did this." And he just tells them, "This is why you did this, and this is why you did that." Um, which basically telling them, not really providing therapy. But since he's coming back, wouldn't you not be afraid anymore? Like, why was Oziel? He wasn't afraid. I don't think he was afraid. He even Judalon Smith said that he acted like they were a paycheck, not patients to him. He would his eyes lit up and he would talk about money or when he talked about them. In sum, the Court of Appeals quasi factual assertion that the therapeutic relationship necessarily disintegrates and that successful therapy is impossible following a threat of physical attack simply is not true. It is contradicted by the experience learned day by day and year by year by tens of thousands of therapists. On the contrary, the empirical evidence establishes that patients' threats are common and that successful therapy is possible even in some extreme cases in which patients carry through on their threats to attack their therapist. The next section, the appellate court erred in holding that there was no ongoing therapeutic relationship despite the extensive contact between petitioners and Dr. Oziel. The therapist's duty of care to patients and to third parties arises when the therapeutic relationship is formed. Absence such a relationship, like Oziel and Lyle did not have, there is no duty to care to that patient or to others. So that is a reason why you might not protect Lyle's um, speech or Lyle's confessions, I guess. Perhaps because of the sensitivity of therapy and the vulnerable nature of therapy patients, courts have found that a patient therapist relationship begins with the earliest contact and continues so long as there is any professional contact. Therapist patient relationship clearly existed between a patient at a drug rehabilitation clinic and a senior counselor at the facility, even though he was not the patient's primary counselor. So that was from this other case. Uh, psychologist patient relationship may be or may have existed where a patient called therapist for an appointment and the therapist referred the patient to another psychologist. One treatise concludes that from the case law, that the following acts by the therapist may create a therapist-patient relationship sufficient to impose certain professional obligations, giving advice, making psychological interpretations, conducting lengthy phone conversations with a prospective patient, giving a patient an appointment, telling walk in patients that they will be seen, and providing psychological diagnostic opinions to the neighbors and friends. In defining the evidentiary privilege, the California legislature has adopted a primary expansive view of the therapist patient relationship by defining patient as any person who consults a psychotherapist for the purpose of securing a diagnosis or preventative, palliative, or curative treatment of his mental or emotional condition. Clearly, petitioners continue to meet this definition even after they allegedly threaten Oziel. So they are pairing them both as patients in their argument. As the Superior properly found, petitioners were seeking therapy during the November 28th and December 11th sessions, regardless of whether they harbored thoughts of taking Dr. Oziel's life at the time. By confessing to their parents' murder, homicide, and discussing the possible reasons behind their acts, defendants were trying to relieve their guilt and seeking palliative treatment for their emotional and mental condition. And if you recall, in testimony, Erik said he was feeling so guilty, he was so remorseful, he was just like a nervous ball of energy, constantly on edge. He felt guilty. He wanted to take his own life, and seeking Dr. Oziel was a way to kind of absolve himself, to get this heavy weight off of his shoulders by, talking about the situation. Even the Court of Appeal had acknowledged the large portions of, didn't I read this part? Um, no. Even the Court of Appeals has acknowledged that large portions of the November 28th and December 11th sessions were devoted to discussing other subjects, um, not just the homicides, but the petitioner's emotional condition. So they were talking about the emotional condition of how they were feeling after such events happened. So during the November 28th session, Erik Menendez expressed remorse and discussed his thoughts about taking his own life with Dr. Oziel. It is thus clear that Erik Menendez was seeking palliative treatment at the November 28th session and was therefore a patient under the California Evidence Code. It makes no sense to rule, as did the Court of Appeal, that no therapeutic relationship existed despite the facts that Dr. Oziel continued to schedule appointments and hold therapy sessions with the petitioners. These sessions continue to be held in his office, and petitioners continue to discuss their psychological problems. Dr. Oziel continued to advise petitioners, and petitioners continued to assume that these sessions were protected by confidentiality. So why would they not think that? Here's a footnote. In addition, there does not appear to be any evidence that Dr. Oziel altered his charging practices after October 31st, when petitioners allegedly issued the threat. So the 31st is when the threats happened, and then they came back to two separate times. Presumably, Dr. Oziel continued to expect payments for services provided after that date. And remember, he attended the funeral services and was supposedly, providing therapeutic guidance to the brothers the whole entire day of this therapy session for like 8 hours, or for the funeral, for like 8 hours he was with them, and he did not forget to charge them, though. We'll have you know. So that was brought up on the stand that he did charge them for providing comfort and therapeutic services to the brothers during the funeral, which I just can't. Can you get any slimier than that? The APA is aware of a single case, and neither the Court of Appeal nor the real party in interest has cited any in which courts have ruled that despite all these factors, a patient therapist relationship does not exist. The unsupported statement of the Court of Appeals that therapy must have ceased should be disavowed by the court. The Court of Appeal ruling would lead to absurd and dangerous results. In holding that the therapeutic relationship terminates ipso, I don't know what that is, eo ipso, at the instant a patient communicates a serious threat to a, let's start over. In holding that the therapeutic relationship terminates at the instant a patient communicates a serious threat to a therapist, the Court of Appeal apparently did not consider fully certain implications of this ruling. So you guys were wrong. Here's why you're wrong. If there is no longer a therapeutic relationship, some, though not all, professional obligations may cease. Thus, under the Court of Appeal ruling, after a threat, the therapist would be under no duty to give competent advice to the non patient, even if sessions continue and both parties believe that a therapeutic relationship continues to exist. The therapist would have no duty to refer the patient to others if needed for special care. As the Court of Appeal held, the therapist also would have no duty to maintain the confidentiality of what is said by the person who is no longer a patient. The therapist would not even have a duty to take adequate notes or to keep records of subsequent sessions. There, these are the consequences of ending the therapy relationship by operation of law. So you're ending their relationship on a technicality, whereas the patient still believes and thinks that um, their conversations and prior conversations are all protected and confidential, but the court is just saying, nope, not the case. Even apart from these disastrous collateral results, and with respect to only factor that apparently concerned the Court of Appeal protecting the public, its decision would backfire. The therapist in such circumstances would have no ongoing duty to warn or protect third parties. Bam, they got you good there, Court of Appeals. They got you. For example, if after threatening Dr. Oziel, the Menendez brothers had communicated to a threat to take their grandmother's life under the Court of Appeals ruling, Dr. Oziel would have had no duty to warn or protect the grandmother, since Dr. Oziel was no longer acting as a therapist. Thus, ironically, in seeking to fashion a rule that would broaden disclosure of relevant information in cases involving dangerous patients, the Court of Appeal ruling would terminate the obligation to make essential future disclosures. That is such a good argument. I can't believe this didn't win because it is like that is so well thought out to me. Like I never would have thought of that, but they just were like, bam, we just mic dropped in your face. As noted above, potentially dangerous patients can become angry at a wide array of people. Often therapists have to warn different people of different risks at different times. But the Court of Appeal ruling would short circuit this whole process. It would end therapeutic obligations and public safety obligations at the first threat, regardless of any future dangers of which the therapist becomes aware. This would result in less protection for the public. Whether a patient therapist relationship exists depends on the reasonable expectations of the patient. Most therapeutic relationships terminate eventually. After termination, most, but not all, of the parties' rights and duties are diminished. Legally, therefore, the question of when therapy terminates is a crucial one. APA believes that courts should examine the totality of the circumstances in each case and decide whether therapy was ongoing. However, the court's analysis should be based principally on the same factor which warranted the judicial recognition of confidentiality in the first instance, the reasonable expectations of the patient. The therapeutic relationship should be considered ongoing if, under all the circumstances, the patient reasonably expects that the relationship exists. This standard reflects the legislature's conclusion that patient expectations and intentions generally determine whether a therapeutic relationship is formed and communications are confidential. So, this is coming straight from a particular ruling. So, how they it just baffles me how one side of the court can look at it one way and another side of the court can just look at it a completely different way and say nope, it's completely out, it should be out, and this side should be yep, it's in. It, it baffles me how people can look at things and twist them in such ridiculous ways, like the Commonwealth in the Karen Reed trial specifically. They like to twist and gaslight. And there might have been a little bit of that in this trial. I think a lot of prosecutors do that. And, defense attorneys can be, excuse me, can be guilty of that too. But I think a lot of prosecutors do a lot of twisting sometimes to fit their narrative when, excuse me, I sound like a frog. Hold on 1 second. All right. Sorry. I don't remember what I was saying now. Really had to clear my throat there. So, yeah. Anyways, back to it. Patient's expectation is the key factor, is evident from the language of the evidence code provisions themselves. Yeah, I was just baffled how some people can twist things one way and gaslight us in certain directions. Section 1012 defines confidential communication as a patient-therapist communication transmitted in confidence by a means which, so far as the patient is aware, discloses the information to no third parties. Likewise, 1011 defines patient as one who consults a psychotherapist for the purpose of securing a diagnosis or preventative, palliative, or curative treatment. Thus, the patient's purpose in seeking therapy and the patient's awareness and expectation of confidentiality are the essential factors in determining whether a communication is privileged. It's such great arguments in this. So, interpreting evidence code court was mindful of the justifiable expectation of confidentiality that most individuals seeking psychotherapeutic treatment harbor. The therapeutic relationship certainly should be deemed to exist if, as in this case, both the patient and the therapist believe that therapy is continuing. A patient should not lose the right to confidentiality regarding embarrassing and intimate details unless he or she should reasonably expect that events have arisen such that confidentiality no longer exists. When the therapist no longer sees the patient in his office or his or her office, no longer sees the patient alone, no longer discusses the patient's problems, and no longer charges the patient, a court could reasonably conclude that the patient should have realized that the therapeutic relationship had terminated. Of course, there may be gray area cases where the reasonableness of the patient's expectations is far less clear. However, courts should be very reluctant to impose after the fact an interpretation that no therapy relationship existed when all the parties to the relationship at the time believed it did. In State versus Miller, the Oregon Supreme Court adopted essentially the reasonable expectation standard proposed here. In that case, defendant telephoned his brother and stated that he had just taken the life of another person. The brother advised the defendant to telephone a mental health professional. The defendant then called a state hospital, told the receptionist that he had committed homicide, and asked the person to speak to a psychiatrist. The receptionist summoned a psychiatrist who spoke to the defendant for 10 to 15 minutes in an effort to keep him on the line while the police traced the call. During their conversation, the defendant made several incriminating statements to the psychiatrist, which the state later sought to introduce into evidence at the defendant's trial. The court in Miller first noted that the question of whether a patient's statement is confidential depends on the intent of the patient, which may be inferred from all the circumstances. It also held that whether a patient-therapist relationship exists at all and whether the patient-therapist privileges applies is determined by the reasonable expectations of the patient. Thus, according to the court, if a prospective patient meets a therapist in a supermarket and immediately makes an unsolicited confession, there is no reason for the patient to believe that the therapist has agreed to a therapeutic relationship, and the patient does not have a reasonable expectation that the communication will be confidential. In contrast, if a prospective patient talks to a licensed psychotherapist in a professional practice setting, such as a mental health clinic or a private office, or such as that guy calling the hospital to speak to a psychiatrist, the patient could fairly infer that the psychotherapist had indicated a willingness to enter into a confidential relationship. I agree. I agree. Consequently, the court in Miller found that the patient therapist relationship existed because the defendant reasonably expected that his disclosures would remain confidential. In contrast, the Court of Appeal erred in this case because it ignored all of the factors indicating that petitioners had a reasonable expectation that their therapeutic relationship with Dr. Oziel was ongoing, and it relied on factors that are irrelevant to the petitioner's expectations. Sorry. Um, all right, here. The Court of Appeal based its ruling primarily on its view that petitioner's relationship with Dr. Oziel must have disintegrated once petitioners threatened Dr. Oziel's life. Such threats, however, did not alter the petitioner's expectations, and hence that's why they kept going back and talking to him and returning. As the Superior Court found, all of the sessions were intended for the purpose of therapy, not for confessions. But Dr. Oziel may have had some other expectations of the therapy sessions, but the brothers, thought, they were going to seek therapy. As we showed above, the therapeutic relationship does not always terminate upon the issuance of a threat directed at the therapist. Such threats are common, and there is no empirical support for the assumption that a threat always results in the disintegration of a therapeutic relationship. On the contrary, threats can be part of the patient's airing and resolving of other problems. Consequently, there was no reason for either petitioners or Dr. Oziel to expect that the relationship was legally deemed terminated following that threat. Yeah, I mean, Oziel continued to see them, so why would you think that there was, some issue? Why would you think anything changed? The Court of Appeal also appeared to base its holding on its inferences as to Dr. Oziel's motives. It said that the doctor's primary objective was not to provide treatment to petitioners, and that Dr. Oziel was motivated by self-preservation. This apparent finding of fact was substituted for the opposite finding of the Superior Court, and it certainly contradicts the reasonable expectations of the petitioner slash patients. Once again, the Court of Appeal went too far. There may be many reasons why a therapist might not feel that therapeutic progress is his or her primary objective. Suppose the therapist is burnt out and only wants easy money. Dr. Oziel. Or that he continues therapy so he can write a book about criminal minds I have known. Did Oziel do that? I believe Oziel might have written a book or tried to, anyways. Or that I'll look into that. Um, I would not put it past him. His narcissistic self probably went into that, you know, situation thinking I can make money off of this. I can do a book deal. I can make movie deals and blah blah blah. That was Dr. Oziel seemed very opportunistic on the stand. And that is also how Judalon Smith, his mistress, portrayed him. All right, or that he wants the patient to do harm because the therapist also hates the proposed victim. All of these actions are bad, unethical, and perhaps actionable. So if the therapist had some unethical and maybe even an actual actionable reason that he was going into these, that's different than and very much borderlines on ethical when it comes to going into a session when the brothers think that they're getting therapy and you're in it for, your self promotion, your self entitlement. But does it make sense? A court of appeal ruling implies that the patient who is unaware of these motives of his therapist and is still pursuing therapy nevertheless loses his confidentiality rights. We submit that it does not make sense. Obviously, oh, I missed the thing. Oh well, I don't know where it was. I'm not going to go back. Obviously, oh, I didn't miss it. A patient entering therapy does not have any idea as to the therapist's motives for taking the case. Such motives may be improper or, as in this case, complex and mixed. Dr. Oziel's motives appear to be complicated. The Superior Court, which heard the parties' testimony, found, as a matter of fact, that the parties, including Dr. Oziel, intended all of the sessions to be for the purpose of therapy. Even the Court of Appeal, which rejected this finding, held only that Dr. Oziel's primary objective was not to provide therapy. But the boys wanted therapy. Oziel wanted something else. That makes him unethical and means he never should practice or be anywhere in any kind of therapeutic, or I think he might even do like coaching now, which is just like the same as therapy, but without any regulations, which is worse. So, but confidentiality should not depend on divining the subjective motives of the therapist. To hold otherwise would require patients to assess their therapist's motivations at the beginning of each session, surely an impossible and unreasonable task, and for courts to try to reconstruct these motives later. That would be impossible and surely stupid. In Miller, the court faced a situation where the therapist was not motivated at all by a desire to help the patient, but only by a desire to keep him talking until the police could trace his call. Despite this, the court found that the motive of the therapist was irrelevant in determining whether the patient therapist privilege applied. Because where a patient consults a psychotherapist for professional assistance for a mental or emotional problem and reasonably believes that the psychotherapist is willing to embark upon a professional relationship, the fact that the psychotherapist has a secret ulterior purpose for the interview or examination will not prevent the patient from claiming the privilege. So it is the patient who claims the privilege. As to the confidential communications, to hold otherwise would effectively transfer the privilege from the patient to the psychotherapist. Such a shift is not supported by the language of the rule and or underlying purpose or case law. And it would be like, let's say a therapist and patient had a great, um, a great relationship. Suddenly something happens and something goes wrong in that relationship. And the therapist gets mad and angry at their patient and they might, retaliate and do things in that case. I don't know why, or how often that might happen, but who knows? You can't, if a therapist all of a sudden just changes their mind about someone and we're going to say, well, now nothing's, it's all that stuff that I told everybody was private before, I'm going to release it because now, I've changed my mind and it wasn't private. If it's their intention, they can just change it on a whim. So we can't live a life like that. That would be a lawless life. All right, so the case should rule likewise. I don't know how I missed this, but this implies that helping petitioners was Dr. Oziel's secondary motive. Also following petitioner's threat under Tarasov, Dr. Oziel could have informed the police and could have provided the police with as much confidential information as was necessary to secure his own safety and the safety of his loved ones. The fact that Dr. Oziel chose instead to take less drastic measures and to try and preserve his safety while continuing to treat petitioners suggests that Dr. Oziel was motivated in part by a desire to provide continued therapy to them. Yeah, he continued seeing them. Finally, when it did consider petitioners, the Court of Appeal mistakenly focused not on the reasonable expectations but upon their motives. See Menendez. Petitioners' primary objective was not to receive therapy, but to provide themselves with a possible psychiatric defense. This was inappropriate. And who is the court to say that that's what they were going for? That's what Dr. Oziel said, was that he could help them with a proper defense. But they were going there for therapy. So this was inappropriate of the court to rule that way because the patient's motivation should have no bearing on the duties of the therapist to provide appropriate care or to protect confidential information. For example, a patient seeking therapy may be motivated not by a desire to receive treatment, but rather by a desire to appease his family or his employer, or by an attachment he has formed to his therapist, or by a desire to comply with a court order. In each case, the patient may not really have therapy as his primary objective, but once he enters into a therapeutic relationship and he has a reasonable expectation that the therapist will perform competently and not reveal confidential information, the law must respect that expectation. The law must respect that expectation of the patient. Whether or not the patient is sincere, he nevertheless is revealing confidential information. So, regardless if that's your primary reason to seek therapy, you are still under the assumption that there's a privilege there. So, the Court of Appeals holding also is impractical since it requires a post hoc divination of motives of mentally ill persons, a task that courts will find daunting at best. The Court of Appeal held the petitioners in this case were primarily, not solely, motivated by self interest. Most individuals probably have mixed motives for entering into therapeutic relationships. Not all such motives are articulated or even conscious, and many motives may be unrelated to the goal of receiving treatment. But this does not mean that therapy is doomed to failure or that the therapist should not be held to the normal legal duties. We have a thing here. The impracticality of the Court of Appeal ruling is also evident if one considers who pays for the therapy sessions. If therapy is deemed to terminate as a matter of law in certain situations where neither party reasonably expects that termination has occurred, patients and practitioners will continue to bill third party payers for ongoing sessions. In order to determine whether therapy is ongoing and reimbursement appropriate, payers would have to assess the motivations of the parties at all times, which is clearly an impossible task. Therapists may be denied payment in a variety of circumstances where legal termination has occurred, but therapy continued and therapists, blah, blah, blah. You get the point. I'm not going to read all that. But yeah, so they make a very good point. If you're going to say that their legal duties stop when there's a threat, or because a therapist says, my motive going into this therapy session isn't for therapeutic purposes, then what's the point? Why do we have these, like, it's lawless? We're just living in a lawless town because then any therapist can at any time say, "Oh, yeah, I'm just going to say my motives are this and I can release whatever I want," which is obviously unethical. Um, This court should decline to adopt a rule that will entangle courts in endless efforts to sort out psychological motives. Instead, it should rely on the more objective and verifiable standard of patients' reasonable expectations. A rule that focuses on the reasonable expectations of the patient is impractical. This court should rule that whether a therapeutic relationship exists or is ongoing determines on whether, under the totality of circumstances, the patient reasonably expected that a therapeutic relationship existed. This rule has a number of advantages. First, such a standard is both flexible and practical. By focusing on reasonable expectations rather than motivations, courts need not inquire into the unknown and perhaps unknowable purposes underlying each party's actions. Rather, courts need only ask whether the patient had a certain expectation and whether that expectation was reasonable in light of the facts. Second, such a rule would preserve the relationship of trust that is the cornerstone of successful therapy. Patients will only retain trust in their therapist when the therapist's actions, especially regarding confidential communications, conform to their reasonable expectations. Footnote here, the importance of patients of having their communications remain confidential cannot seriously be disputed. Numerous studies have found that confidentiality is crucial to the establishment of a trusting relationship between patient and therapist, and thus is crucial to successful treatment outcomes. Um, there's a whole bunch of gobbledygook in here, so I'm not going to read it all. Sorry. We get the point. All right. So, as this court has recognized, the right to confidentiality draws its substance primarily from the psychological needs and expectations of the patients. And that's where it should be coming from. In this other case, oh, that's what they're quoting from this other case. Consequently, this court has declined to sanction unknowing waivers of confidentiality by patients because such waivers result in the unexpected and unintended forfeiture of a privacy right. This court should decline to adopt a ruling that would result in loss of confidentiality in a variety of situations in which the patient reasonably expects it. In Tarasov, of course, sanctioned the unintentional waiver of confidentiality, but only in very limited circumstances and only to further the compelling state interest in public safety. I have no idea what that meant. Sorry. All right. So finally, the ruling of the Court of Appeal. They've said finally already. This is a long one. Sorry, guys. The Court of Appeal would cause therapists to discontinue therapy to potentially dangerous individuals at the exact time when they are most likely to become violent. Assume, for example, that a patient has just communicated a serious threat to his or her therapist. If the Court of Appeal decision is affirmed, an ethical therapist will have an obligation to inform the patient that therapy may have been terminated in the eyes of the law, right? So if therapy is no longer, if they no longer have that obligation, they have an obligation to tell you they're no longer obligated to you by law. 18. The APA's ethics code provides that where appropriate, psychologists inform their clients of the legal limits of confidentiality. There you have it. They should have told him if that was the case. Oziel should have been like, okay, you guys can come in for therapy, but legally, I'm not your therapist anymore. So anything you say to me isn't confidential because you threatened me. But you can still come in and let me record you. Sure. See how ridiculous this is? Under these circumstances, candor and integrity would require the doctor to advise a patient at the outset that he will violate his confidence and inform law enforcement authorities of their discussions. Under these circumstances, many dangerous patients will simply end therapy because you don't want to say something that's going to get you in more trouble, right? So why would if Erik and Lyle had gone into those sessions knowing that Oziel was going to go to the law or turn the tapes in, even though it was Junelad Smith who did it, but he never expected any confidentiality, let's be honest. He was taping them for purposes of using it in court because he told him it could be I could help you with your legal strategy, your defense strategy. So it would have been, if the boys had known going in that there was no confidentiality, I'm sure they wouldn't have done it. They would have had a choice to make at that point when he tells them, I am no longer legally obligated to represent you as a therapist. Okay, thank you. Moving on, we'll go get a different therapist. In Tarasov, this court stated that the fears of the mental health community regarding the chilling effect of the duty to protect were entirely speculative. Perhaps they were at the time, but an impressive body of research now confirms the importance to patients of strict confidentiality. See citations within. All right. Moreover, Tarasov and its progeny created a small exception to the general confidentiality rules. The vast majority of patients' communications to their therapists remain protected even after Tarasov. In contrast, the Court of Appeal ruling here blasts a gaping hole in the general rule of confidentiality. Following a threat or other termination by operation of law, everything a patient says may now be disclosed to the public. That's ridiculous. The Tarasov exception differs from the Court of Appeal holding in another respect. Many patients understand and accept the policy underlying the Tarasov because it applies to very specific disclosures. In fact, many dangerous patients seek therapy because they know they are potentially violent and they wish to have appropriate steps taken to prevent harm to others. Um, 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 um. Thus, when a therapist gives a specific Tarasov warning, he or she may sacrifice the patient's confidentiality to a limited degree, but not sacrifice the patient's broader trust. In contrast, it is impossible to retain trust when the patient knows that the therapist is under no obligation to hold any of the patient's communications in confidence. Most patients and therapists, therefore, would likely choose to discontinue therapy in these sessions. This result would be inhumane since effective treatment is often possible despite a threat to the therapist. It also would be dangerous. If, as can be reasonably assumed, patients communicating threats have more propensity toward violence than the patient population as a whole, then the likely consequence of automatic termination following a threat is that the most dangerous patients will be terminated from the very therapy that may be needed to avoid harm. Sorry. So they need the therapy to calm them down, emotionally. Um, but cutting off their therapy would cause more problems because they need the therapy. All right, so this court has recently been forced to deal with a tragic consequence that can result from the premature termination of a therapeutic relationship with a dangerous patient. In People versus Clark, a therapist abruptly terminated treatment after receiving threats from a patient. Distraught by the feeling of abandonment at a crucial point in therapy, the patient set fire to the therapist's house, taking the lives of the therapist's husband and permanently disfiguring the therapist. That is awful. That's awful. All she was doing was trying to protect herself by cutting off therapy, but as we know, that's a dangerous time to do it. So clearly, this result does not reflect the legislature's intent or sound law. This court should not endorse a ruling that would lead to such disastrous consequences. Conclusion: for the foregoing reasons, the APA respectfully urges that this court vacate the ruling of the Court of Appeal and 1. Rule that the November 28th and December 11th sessions between petitioners and Dr. Oziel were conducted with the reasonable expectation of confidentiality, and 2. Holds that pursuant to Wharton, the trial court should admit into evidence only these statements from any session that formed the content of or directly triggered Dr. Oziel's warnings to others. So all that other stuff that Dr. Oziel brought to trial should never have come in. And that is according to the APA, where's their names? Attorneys for the American Psychological Association and the California Psychological Association. So there we have it. That went a lot longer than I intended, but we went through it. We got through it. And I hope this helps kind of help you understand, like, there's so many nuances in the law and how things can be misconstrued and construed in different ways and twisted and turned. And it's amazing to me how we have two sides, sometimes three, four sides to every story. And um, somewhere the truth is, somewhere the right side of the law is. And we have to kind of read through it all and figure it out ourselves, which is just insane. And we have these lawyers and judges who can't even do it. And yet we're supposed to understand our laws and abide by them. So it's crazy. All right, guys. Thank you guys so much for watching. And please hit that like button on your way out as you go off and enjoy your New Year's celebrations. I thank you guys so much for being a part of my channel for 2024. I hope that you continue to be with me in the upcoming year. And we will continue to cover we will continue to cover Menendez brothers and other cases that I find victims need a voice. So please don't forget to hit the subscribe button and the like button on your way out, and I will see you guys in the next one. Take care. Happy New Year's, guys. Bye now.